It's 9 a.m. Let's begin this morning. We're on day 3 of the hearing in OCC 25875 relating to primacy for Class 6 injection wells. We've reached our 3rd public comment session. I don't see anyone in the room I don't recognize, so let's go straight to the platform. Sheila, who would like to go first?
First, we have Mike Eisenfeld.
Oh, thank you. Mr. Eisenfeld, would you please spell your first and last name?
Mikeeisenfeld.
And do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead.
Madam Hearing Examiner and Commissioners, thank you very much for the opportunity to give public comment. My name is Mike Eisenfeld. I work for San Juan Citizens Alliance as the Energy and Climate Program Director. San Juan Citizens Alliance has about 1,000 members in the Four Corners area. The reason for my comment is that we've been very much involved in the concept of carbon capture, carbon sequestration here in the Four Corners for many years, and very much involved in this idea of primacy for the state of New Mexico. And I think that the primary concern that we have is about public health and safety. You heard in some of the testimony about the idea of Farmington being an epicenter for carbon sequestration. And we're extremely concerned about that due to the fact that carbon sequestration could create a lot of problems for us up here. We were part of the public comments and public meetings in Farmington, and at that point, we noted that there was no translation into other languages, that some of the community members that are very diverse. And we're also very much aware that it's a very complex scientific and legal issue. The potential for these sequestration sites to interact with the over 60,000 oil and gas wells known in the Four Corners area is a very, very significant concern. We feel like there needs to be more information provided about pore space, well spacing, mineral owner notification, safety notices, the concepts of things like split estates. It seems like we need more assurance about the concern over New Mexico's ability to oversee the program. A lot of our information was from the carbon safe projects here, which are carbon storage assurance facility enterprise projects. One, for example, is a well site that was drilled near Aztec that was going to be associated with the San Juan Generating Station, which no longer exists. The idea was to sequester carbon dioxide from that facility, and there was very little information provided to the community. So we would encourage a lot of the public safety measures, interference tests, concerns over liabilities, concerns over just public health and safety at every step of the way. I would suggest that we're at a real characterization phase of the ability to sequester CO2. And then finally, we question what New Mexico is thinking in terms of sequestering CO2, because capturing CO2 is a very complex issue. And we would suggest that the emphasis should be to not create that CO2 emissions in the first place. Thank you very much for your time.
Thank you, Mr. Eisenfeld. I'm not sure why it's echoing. Do we have Mr. Palladino next?
Well, could we resolve, I apologize, but could we try to resolve the audio issue before we move on to more?
I think it did.
Okay, can anybody with their laptops joined on the Teams platform in the room, can you check and make sure that your microphones are off and that your speakers are off?
Thank you all. I apologize.
Are we resolved? I think we are.
So next up is Charlie Palladino.
All right, Mr. Palladino, can you unmute yourself? Hello.
Hello.
Would you spell your first and last name, please?
Yes, my name is Charlie Palladino, Charlie Palladino.
Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead.
Hey, my name is Charlie Palladino, and I am a policy advocate with Earthworks. Thank you for the opportunity to comment today. And I would like to focus my comment on the procedure for transitioning from Class 2 wells to Class 6 wells. The Class 6 rules outline certain public safety measures intended to be commensurate with the risk associated with long-term CO2 storage. Class 2 wells, on the other hand, were not designed for this purpose and do not require these same measures. When the EPA first announced that the Class 6 rules, it explained the difference between the two rule sets on the grounds that Class 2 wells that use CO2 for enhanced oil recovery would be handling less CO2 and therefore would pose less risk. However, the EPA also stated that if the business model for enhanced oil recovery changes to focus on maximizing CO2 injection volumes and permanent storage, then the risk of endangerment to underground sources of drinking water is likely to increase, and such wells may need to be re-permitted as Class 6 wells. Given that the federal tax credit used to incentivize the use of CO2 for oil recovery was recently increased, it is likely this practice will also increase. In anticipation of this, I think New Mexico's rules should resolve the ambiguities that remain in the process for deciding whether a well needs to be reclassified. The federal rules, which these rules closely resemble, require a Class 2 well to transition to a Class 6 well when two conditions are present. First, when the owners of the well inject CO2 for the quote primary purpose of long-term storage, and if there is an increased risk to underground sources of drinking water compared to Class 2 operations. But there are questions around how this transition is implemented. For instance, it's not clear when the review process is triggered, how to define primary purpose, or how to properly evaluate the factors in determining whether an increased risk to underground sources of drinking water exists, like injection and pressure rate thresholds that would then require conversion. Even Texas takes a more precautionary approach where the state requires operators to reclassify a well if either the primary purpose of CO2 injection is long-term storage or there is an increased risk to underground sources of drinking water, instead of requiring both conditions to be present. This approach better addresses the nature of the risks inherent to geologic storage of CO2. Whether or not the primary purpose of the injection changes, the risk associated with the change in injection should by itself be enough to trigger the stricter Class 6 rules. And thank you. That's it for me.
Thank you, Mr. Palladino.
Okay, next will be Felicia Guillen.
Ms. Guillen?
Hello.
Hello, would you spell your first and last name, please?
Yep, Felicia Guillen, FELEECIAGUILLEN.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Good morning, hearing examiners. Thank you for the opportunity to give public comment. My name is Felicia Guillen, and I am an organizer with New Mexico No False Solutions Coalition. Today, I'm here speaking in deep concern to New Mexico assuming primacy over Class 6 CO2 injection wells. I really urge the Oil Conservation Division to strengthen these proposed rules because if the state is ultimately granted primacy, New Mexicans deserve protections that go beyond beyond the federal minimum. The burden really should be on the state to prove it can regulate this program better than EPA, and I don't believe that this burden has been met. OCD is already responsible for overseeing one of the nation's largest oil and gas industries, yet New Mexico continues to struggle with orphaned and abandoned wells, delayed cleanups, inspection backlogs, and enforcement challenges. And so if OCD lacks the capacity to fully address existing responsibilities, it should not take on an entirely new and highly technical regulatory program. I also want to center water in this conversation because New Mexico and our communities are already facing the realities of drought, groundwater depletion, and climate change. For many Indigenous people, water is sacred. It's not simply a resource to be managed, but rather a living relative with deep cultural, spiritual, and ceremonial significance. Acequia communities also have stewarded water collectively for generations, recognizing that our shared survival depends on protecting it. And I want to make it very clear that any failure of Class 6 wells that threaten groundwater is not just an environmental concern. It threatens our very cultural traditions, our agriculture, our drinking water, and our ways of life that have sustained New Mexico for centuries. And so these rules should reflect that reality by placing the highest priority on groundwater protection. Beyond questions of capacity, I'm also deeply concerned about what CCS represents. CCS is being promoted as a climate solution, but in practice, it serves as a lifeline for the fossil fuel industry. Rather than reducing dependence on oil and gas, it allows companies to continue extracting and burning fossil fuels while claiming future emissions will be managed underground. Communities that have already suffered the harms of extraction should not be asked to shoulder another generation of industrial risk. If New Mexico nevertheless receives primacy, these rules must be substantially stronger than the EPA's baseline requirements. At a minimum, they should require a 2,000-foot safety buffer between Class 6 wells and homes, schools, hospitals, and other occupied buildings. They should also require mandatory industry-funded training and emergency preparedness for local first responders before any permits are issued. And they should also strengthen environmental justice requirements to ensure that meaningful consultation with frontline communities and really require robust financial assurance so taxpayers never bear the costs of monitoring or cleanup. New Mexico should not seek primacy simply to make permitting faster. Regulation exists to protect people, to protect our water, and to protect our future generations. New Mexico currently doesn't have any Class 6 well permits at the moment, and maybe we should keep it that way. So I really urge the hearing examiners to adopt the strongest possible protections that exceed federal standards and truly put our communities first. Thank you.
Thank you, Ms. Guillen.
Okay, next is Mandy Sackett.
Ms. Sackett?
Hello, my name is Mandy Sackett, MandySackett.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Good morning, Chair Chang and Commissioners. My name is Mandy. I'm the New Mexico lead campaigner for Earthworks and a certified thermographer. I've stood in schoolyards and front yards close enough to industrial oil and gas wells to see the equipment from a playground. These are different wells with different risks, but the question of how close is too close is the same. We're here because we want New Mexico to get these rules right. Once primacy is granted, these are the rules that will govern carbon dioxide injection in this state for decades, and the wells themselves are meant to hold that carbon dioxide for centuries. And the people who live near them will be living with these decisions long after all of us in this room have moved on. My comment today is about one specific gap, and that is distance. The draft rules do a careful job at looking at geology beneath the project site, but they don't really have any minimum distance between an injection well and what's above the ground, like homes, schools, and child care centers. A project could be permitted next door to an elementary school and still satisfy its siting requirements in this draft. Other states have already addressed this. Colorado requires 2,000 feet with no exceptions. Louisiana, Wyoming, and West Virginia and New Mexico can learn from these examples. We suggest that this agency, at a minimum, adopt a public safety setback and apply it without exception. New Mexico doesn't have to choose between a weak rule and no rule at all. Other states have shown what a strong rule looks like, and I think New Mexico should meet or beat them. We wouldn't cite a school next to an active industrial well, so we shouldn't allow it to happen the other way around. Thank you.
Thank you, Ms. Sackett. Is there anyone else on the platform who'd like to offer public comment this morning? The next opportunity is 9 a.m. tomorrow morning. No? All right. We'll return to the technical case then. When we broke yesterday, Commissioner Mpoma was questioning the second division panel. Commissioner Mpoma, do you have additional questions?
Yes, I do. Thank you. And I promise to be fast. Yeah. Mr. Hills, yesterday we ended on the MIT and then also the operational monitoring. So I'll continue with that. Now, there are instances where monitoring equipment probably fail. So similar, let's say a gauge, something like that. So my question to you is, how much missing monitoring data is acceptable before injection will be more or less stopped?
No, it's a good question. I have to say it depends upon which of the bits of monitoring data. So if you're monitoring pressure and temperature on the surface, you could lose communication for a few minutes, and that wouldn't justify it. But if you've lost for a period, I think what I would say is more than 24 hours, especially on pressure, it's a good reason to cease injection at that point, or to at least resolve that issue.
And will this be in the guidance, or it will be not necessarily in the rule?
I would recommend that in guidance.
Okay, thank you. And must operators maintain backup instrumentation, power, and communication, or not necessarily?
It's not spelled out in the rule, but it is common in most devices right now.
So it will be part of the guidance?
Yes.
Thank you. Now, let's say existing class 2 wells, they do have a way to plug wells, right? So there's a strategy for them to plug wells. Now, my question is compliance with the plugging standard in effect right now?
Yes.
Yeah, when the legacy wells was abandoned, sufficient, or it must meet modern class 6 corrective action standard?
Yes, that's correct. It must meet, there's a regulation in place now that requires that. So when permitting a class 2 injection well, part of the permit process again includes the evaluation of the AOR and identifying wells within the AOR, and then determining the corrective action required to plug that well with materials that are compatible with the potential material of the inject date. So it's in place now, and it's also spelled out within the Class 6 rule.
Now, let me ask, if, let's say, a source of CO2 changes, assuming it is a gas processing plant, that was what was used in the permitting process, and now it changed to, let's say, a coal power plant. My question to you is that will the different source facility or capture technologies require separate compatibility evaluations of the CO2 stream?
If it changes, it's required within an AOR redetermination section. So if you have a change in the inject date that was used to determine all the inputs for the material choices, then you are triggered within the AOR, and you have to re-up that actual concentration or that inject date and go through the same process on a reiterant basis.
Now, let's talk a little bit about emergency response and protection of nearby communities. So the first question will be, what specific events automatically require immediate cessation of injection?
Specific event, there is any known impact to or possible impact to the USDW requires immediate cessation.
And I do know from EPA that the whole purpose of the Class 6 is more or less to protect USDW. Now, you just answered that if there is a situation where there could be something happening to the USDW, then there has to be cessation. Now, what about if, let's say, the CO2 move into on-perimeter zones? What happens?
Yep. So it's the same applies.
Okay.
The two primary requirements, A and B, are in general at the very top. What you just said, it's the USDW and potential of communication between formations, unpermitted.
Now, another important question that I do have is, does the operator do have discretion to continue injection whilst we are investigating an anomaly?
Yes, they do. They must report the concern, and they have the discretion to investigate in communication with the OCD to identify the issue.
But they do have the discretion to continue injection, or?
They do have the discretion to continue injection, yes.
Okay. And my last question to you is, so there was a discussion about the local responders. So will there be the responsibility of the operator to provide the equipment, training, and funding to the local responders?
No, that is not required.
Okay.
Training and awareness, but not what you just stated.
Okay, so I do not have any further questions for you, and I'll move on to Ms. Rainey. Thank you for your service to the state, and then also putting this huge experts all together to support the Class 6 primacy application here. Now, my first question to you, I will focus mostly on the public notice, landowner, tribes, and community engagement. So we made mention a lot about affected community. So how would you define the affected community?
Thank you for the comment. Affected community is pretty broad. It's listed in 19, 15, 41, Part E, under 5. There are lists of any kind of governmental agency that might be relevant in a permit process. But in terms of members of the public, that could mean surface owners, that could mean mineral or estate owners that are in the vicinity of any proposed project.
Thank you. Now, so why does the rule not establish a clear minimum buffer outside the modeled AOR for direct notice?
If I understood, why does it not include a buffer for the AOR?
Yeah, beyond the AOR for the notices.
So that would be up to the discretion of the director. It's in no way prohibited at this time, but making it prescriptive within the rule might be a limiting factor down the line. So leaving that for guidance and leaving it to the site-specific conditions of any proposed project is the procedure we used.
Now let me ask, will every surface owner, mineral owner, water well owner, occupant within the AOR receive individual notices?
The list of public notice, the list of individuals who'd be contacted would be listed within every given site, but it would be understandable and reasonable for all of the listed landowners, well owners, any property owners within the site to be contacted, yes.
Now let me ask, so will notices be repeated when there is material changes in the AOR?
Correct.
Now, how is the tribal consultation going to be different? How is it going to be different from ordinary public notices, especially if we do have potential plumes that will be going under the NAVA, or let's say the tribes, the tribal pole space?
So in the event that the plume is modeled to go onto the land of a sovereign nation, that would not just simply be notice, that would require an agreement with that tribal nation prior to the issuance of any kind of permit.
Now, in that instance, would the tribal government be contacted before an applicant selects a site or only after a project is proposed?
If a proposed site is in close proximity to another tribal nation, they would need to be contacted very well before a permit is even drafted.
Now, based on your experience in public outreach, do you believe that there has to be independent technical explanation, or will it just be, let's say, the applicant controlling the presentation during public meetings?
Could you please reframe the question? I'm not quite sure I understand.
Okay. So you do have a lot of experience and expertise in public outreach. Now, even during the primacy process, you've visited several places. Now, my question to you is, will public meetings, should it include independent technical explanations, or will it be the applicant controlling those presentations?
For meaningful and effective participation and engagement with various communities, you would need to consider all of the above. You would have to take into account technical experts that might be present at the meeting, also a layperson who's unfamiliar with material. So having the ability to speak to all various audiences and all topics would be essential.
Now, how will the public comments actually influence the permit conditions?
As the public comments are received, the director and the administrators of the program would review each comment and take into consideration the affected parties, how much they would be affected by the given activities, and whether or not the background information provided was relevant or meaningful in the permit application process. And then upon issuing decision, the director would summarize the comments and the response in the decision making.
Now, my next question is a preamble to a follow-up, which is confidential issues. So would the administrative record include modeling data, monitoring plans, emergency plans, and financial assurance estimates in a form the public can evaluate?
Without confidential business information, the public and affected parties would have access to this information, yes.
Then, so let me ask, so how will the confidential business information claims be balanced against meaningful technical review?
That I would leave to the OCD to answer directly and how they would evaluate it.
Mr. Winkle, yeah, can you respond to that?
Yes, I was trying to find in the rule where it explains confidentiality. If an applicant requests it to be confidential and it meets state statute law of being proprietary business information, then we will honor that. If they don't request that, then it is immediately available to the public. Not being an attorney and can speak to state statutes, I don't know where those laws lie and what could be claimed and what could not be claimed.
Commissioner, if I may, this is largely a legal question that we deal with in response to public records requests. So there is a state statute that I can point out for the commission at any point that requires Emner to keep legitimately marked confidential records close. That applies to all of the department, and there are specific exceptions under the public records. So this becomes a question of whether or not, a legal question of whether or not the records are marked as confidential in good faith, and that's a case-by-case decision. But the basic rule is if they are proprietary, then we would not be able to produce those records.
So, Dr. China, let me ask you a quick question here. So normally EPA will allow confidential business information. You submit two, one redacted, and one not redacted. Now, during before, let's say, the project goes into public hearing, how does EPA handles that? Is everything not open up to the public?
Yes, I think when it comes to the redactions, I think you do have to make the distinction that EPA is subject to FOIA requests, and because of that and the burden of that, they've largely made the initial permit applications publicly available very easily. So they are heavily redacted, even when they are publicly available, but that is even before EPA has reviewed them. And so it varies by EPA region, but even drafts going back and forth are typically publicly available, and those will be pretty heavily redacted. But before the actual formal public comment period, EPA typically really stresses to remove those redactions as much as possible. And in my experience, they have really prioritized and explained to the applicants how important that is to the public to remove as much redactions as possible. And to get to your questions about the modeling in particular, there really is no, in my experience, most of that is all open by the time of the public comment period.
And will that be your recommendation to OCD to consider?
Well, I believe here there are laws that govern confidential information that I can't speak to, but I would recommend that in the interest of public transparency, the modeling information should be as public as can be under the applicable laws.
Ms. Rainey, let me come back to you, and thank you so much for the chime in here. So what process allows residents to report all those health concerns and well water changes, seismic events, or other suspected impacts?
There will be a list of reporting guidance for any interested member of the public or any affected party to submit comments, and this would be issued by the OCD and made available to all affected parties.
And my last question to you is that will it be required of the operator to report back to the community how regarding how the inputs they received changed their project?
Updates and any changes on a routine basis would be required, and the plan would be approved for every site-specific project, yes.
Thank you for that. So my last aspect is going to go through the rules, and to make it much easier, I do have printouts of what I'm going to read to you. So just for you to follow, I believe if council, if it's appropriate, I want to share that with the witnesses and all the attorneys as well. Let me keep going.
Oh, very nice.
You have enough copies for us too?
Yeah, I think it's 11, so it should be good.
We'll
We'll prioritize them, yeah.
I think the court reporter might appreciate it.
Commissioner, do you have this electronically?
Yes, I do. It's with, yeah.
So Sheila will be able to pull it up.
Sheila has
online?
it. Yeah,
Okay.
she can.
Okay.
Okay, so I've shared with you what I'm thinking. You know, you did a great job putting all the materials together, and I can assure you that I read everything.
Excuse me?
So I'm also, you know, based on the discussions, I do have some suggestions. These are not really stepstone, but I just want to walk through and see what you think about it. And I'll definitely go through with other witnesses as well. But the strategy, I'll go through the rule with you, and then after that, we just get through what I just showed you so that we can make it really fast.
Can you ask Sheila to put it on the screen?
Yeah, she can. Yeah, Sheila, would you pull up what I shared with you on the screen so the audience can also look at it? But it would be good if you do have the rules with you. So Exhibit 1, 2, and 3, if you have it really handy, that would be good. So I'm going to start off with page 3. Now, so on page 3, and I'm looking at paragraph N or section N on page 3, that will be the definitions beginning with the letter N. You are defining new injection well. You are defining new injection well.
Hang on a second, just to make sure. So it's page 3 of the exhibits, but the first page of the handout that you just made, right?
No, so I'm going to go through the rule.
Okay.
And then later on, I go through this one. So this
You want to do the rule first?
Yeah, so I'm doing the rule first.
Okay, because I just want to let our commissioner clerk know, because she was scrolling.
Yeah,
looking for what,
I will let you know when to scroll. But I'm looking at Exhibit 1 of OCD. That is a rule. So Exhibit 1, page 3. Page 3 of Exhibit 1. And I'm looking at N. Titled Definitions Beginning with the letter N. And you are defining new injection well. And this question will be to the whole panel, so anyone can step in and respond to this. Now, so you've defined a new well right here. Now, my question is, will existing wells that already more or less permitted by EPA under Class 6 be transferred to OCD jurisdiction after primacy?
So your question is, if there is an already permitted Class 6 by the EPA, when we get primacy, it will be transferred over to us? Correct, yes, that is my understanding with speaking with the EPA.
And even all the applications that are still pending with EPA will be moved to OCD?
Correct, yes.
Now, how will those wells be furthered or classified into this rule?
Yeah, to your point.
Okay.
Yeah. Mm-hmm.
So something to look into?
Yes.
Okay. But that one, I do not have any suggested language on that. So something to look into.
Yeah, we definitely can provide some red line.
I appreciate that.
Yeah.
Thank you. Now, I see we are defining, so I'm going to go to still page 3, and I'm looking at S4. So we are defining stratum right there. And I do also see that we are trying to define the storage complex here. So I'm asking, do we need to define storage complex in this rule or not?
I believe in the Class 6 framework that the term area of review is sufficient. The term storage complex is used in some other non-Class 6 regulatory settings I'm familiar with, but maybe it would be helpful if you want to explain what you're thinking and how that might differ from a definition of the area of review.
So the area of review, in my opinion, will be more of is area. So we are using more of the surface, just a contour. But the storage complex defines the actual facility in terms of right from the, you call it the confining zone, injection zone, and then confining zone beneath that. And that together forms the storage complex. So let's say someone is saying we are not protecting, or let's say even how there was a comment about we do have about 60,000 wells in the San Juan Basin. And we are not going to be able to protect all these wells. But you want to define the storage complex for the public to know where the problem is and where we are focusing our area review assessment on. So that is what I'm thinking.
And so in your mind, the storage complex, just so I understand, could it, just within what I call the injection zone, would it expand outside of the area of review or just be constrained within the area of review?
It will be constrained within the area of review.
I would struggle with how that terminology would get fit into the rule personally. I'm open to it, but I think that it's adequately, what your issue is sort of defining the area of potential concern and where CO2 and elevated pressure will be in the subsurface. And I believe the term area of review that's used throughout the rules covers that. Yeah, I'm open to red lines.
Okay. Now, so the definition of the stratum, you're talking about means a single sedimentary bed or layer, regardless of thickness, that consists of generally the same kind of rock materials. And my question is, how does heterogeneity comes in, especially when we are moving away laterally? Does that not account for the same stratum? Or because if you say the same rock material, how do you incorporate heterogeneity in there?
In practice, this is something that is kind of worked through as geologists at the reviewing agency, and the applicants kind of define their stratum. And I would say that the heterogeneity definitely needs to be accounted for in the modeling, and that is clearly outlined in, I believe, the regulatory text and definitely the guidance. And I don't think this definition precludes that. But I'm also open, I think it may be helpful to provide additional clarity in this definition. But I don't think it precludes accounting for heterogeneity within a stratum.
Okay. Something to consider though. Now let's go to page 7. And I'm looking at paragraph G, public hearings. Now, on this one, so my first question is, I want to know if this provision follows strictly according to EPA guidance or EPA rule, yeah.
These were all structured on EPA rules. However, we did add additional public comment period or public comments in a couple of places. I don't know if it's this one exactly, but it is structured off EPA rules.
Okay, so I'm looking at number 2, G2. So you're saying that the director may also hold. Okay. Give me a second. Yeah, so let me read the number 1. The director shall hold a public hearing whenever, that is the key word, whenever he or she finds on the basis of request a significant degree of public interest in a draft permit. So does that mean that a public hearing is not necessarily mandated?
It would not necessarily be mandatory. However, a list of significant interests, there are descriptions of that in Exhibit 18 in the EPA guidance on community engagement and public comment that describe a certain number of scenarios that could occur that would warrant a public hearing.
So, Dr. Schneider, let me ask you, has there been any of these permits permitted by EPA, construction, permit to construct, that has never been a public hearing?
Not to my knowledge, no.
I agree, not to my knowledge.
So we are proposing a very strict rules. So why are we making it discretionary? Because I do believe that the director has to explain as to why he's agreeing, let's say he's permitting that, he's agreeing with the operator to permit that well. He has to more or less explain in a public hearing. So that is something for you to consider, that if you want to be strict, why not make public hearing? Class 2 AGI wells, you require public hearing. So why not for Class 6 wells?
That is a good suggestion, and we will take that into consideration. In fact, I think in part of our review process, we're open to that idea.
Thank you. I appreciate that. Now, still on 7, I will go to I'll move on to H2. And this provision discusses when the director issues a permit, you have 2 years. And the operator can petition to extend that. But if you read through the last sentence of the 2, you're saying that the OCD may approve the extension if it is determined that the delay is justified and consistent with the objectives of the Class 6 program. But my question is, there is no limit as to what is the time frame that the director can say, you can only get 1-time extension or 2-time extensions, 1 year, 2 year. Can you comment on that?
So my answer to that is simple, is OCD is very open to redlining a limit of extension time.
Yeah, so that is something that OCD has to think about.
Yes.
You know, maybe similar to your other rules, what you've been doing, so that it's very clear that operators will know that I do have only, let's say, this period, and the public will know that as well.
Yeah.
Thank
And
you.
for clarity, you're talking about the extension period. Yes.
Exactly.
Okay.
Thank
Yeah,
you.
correct. We agree. We need to look at that.
Okay. Now, I will turn to my sheet. And I will look at, so I've numbered the amendments that I'm proposing here. So I will look at the first one, and I'm looking at page 7 of the Exhibit 1. We're still on Exhibit 1. And I'm looking at 19.15.41.8.I1. So in here, we're talking about the response to the comments. Now, I'm more particular about the A. So you're saying that at the time, I'm reading from 1. So at the time that a final permit is issued, the director shall issue a response to comments. This response shall, A, specify which provisions. So there too, I'm proposing that, I'm thinking about, can we add end conditions to that? Because the director also has to show the changes in the conditions that has been changed from the previous permit that was issued. So that is a suggestion that I'm making here. So something to think about.
Kind of like a crosswalk format of before and then after.
Exactly. And that should also include the conditions,
Okay.
the new conditions that the director is imposing on the permit.
Understood.
Okay.
If this is the first time that a permit has been issued, there may not have been conditions. In the application, there aren't conditions.
I can tell you that OCD will give conditions on every permit.
Yes, but I guess my only point is if this is the first time a permit is issued, there may not be a change of conditions.
Oh, not necessarily the first time.
Okay.
Yeah,
just
not
make sure I
necessarily.
understand
Yeah,
that.
not the first time. This is a time lapse.
And it does say if any, so I think that's.
If any, exactly. Let me see if I have any more on 1. Now, yes, so let's look at on page 4 of Exhibit 1. I'm looking at 19.15.41.8a. And in the director is required to let me read through the B. He's saying that let me read to 2. He's saying that the director shall not begin the processing of the permit until the applicant has fully complied with the application requirements for that permit. And you cite C subsection of subsection A of 1915-42-11 and Mark. Now, what I'm proposing is that, what I'm thinking here is that the director shall notify, so this will be my number 2, the director shall notify the applicant in writing of identified deficiencies and may request additional information necessary to determine completeness or technical adequacy. Would that be something that you believe can be an addition to number 2?
I think it makes sense. I may want to read through everything, make sure it's not covered. My only, I guess, quibble would be I would might number 3, because number 2 covers what's called the completeness evaluation, which is for sort of the first step. And then the next step is the technical review. And I think your suggestion really covers the technical review. So
It will actually cover both, because the technical review, no, the completeness review has to be notified, documented, telling the operator, because there could be instances where my director will not do that, right? But there could be in the future where a director can drag the process. So there has to be that written documentation to the applicant and then also to, let's say, the UIC team.
Can I ask a question on that? So number 2 says the director shall not begin processing, which is fairly robust language. And are you recommending to strike that and replace it, or add your language after that?
No, so that one is specifying that the director has to do the completeness review first before the technical review. So number 2 is just saying that the director will still work on his completeness review until the application is actually processed. So during that completeness review, the director has to notify the operator, these are the deficiencies in your application, and I'm not moving an inch on it until you fulfill those. Documented.
I got you now. This is still covering the completeness review.
Exactly. It still covers that.
I would take your edit, but I would just be concerned. I would want to add it to what's already there to make sure there's not any stringency issues with EPA.
So what are you suggesting?
I believe so. If you just take your language and add it to what's in number 2.
Exactly. That is what I'm suggesting.
Okay, yes.
That's what I'm suggesting. And these are just suggestions, so you can go back, attorneys will look at it, and then during their closings, they can even address that, because this is what I'm thinking.
Yes, it makes sense. I just know that EPA is very detailed in their stringency review, and we just wouldn't really want to have any issues with that. So I think adding your language is a good idea. But
Yeah, and I would add to what he's saying from an OCD perspective. I'd like to keep the language in, if I were OCD, to ensure that the operator knows we're not moving forward until there's completeness.
Exactly.
Full stop, and then your words make sense to add to that.
So Dr. Schneider, you said something though, but so the commission, we are also allowed to add to the rule, right? And so that is even why I'm trying to show you now, because we also want to know the limits. Let's say if EPA is not going to agree to whatever we're talking about here, we should more or less know the bounds as well.
yes, and that's the only role I'm trying to serve.
Okay,
is helping
exactly,
you define
exactly,
that. Yeah.
Exactly, to
But
find that balance. Thank you. Appreciate that. So I do not have anything on Exhibit 1. So if we can move to Exhibit 2 of OCD's application, Exhibit 2. Now, so I'm going to start with page 1 of the rule itself and ask some few questions. So I will start with A, number 3, that is the area of review. And before I ask my question, though, I thought, Dr. Schneider, you agreed to a modification of this?
Yes, I agreed that this needs to be modified. And my recommendation is to actually take the definition in Exhibit 3 and use it in each of the 3 exhibits. So I could point you to it. The definition of area of review, although I'm not seeing it now, I know that somewhere in one of the other exhibits is the full definition of area of review. I think it's in my demonstrative and in my testimony where that is.
Yeah, I do know that there's one in Exhibit 3 as well.
It's in, sorry to interrupt, it's in Exhibit 3, page 4 of 24.
Exactly.
And that, I would just replace wholesale this definition with that definition.
Okay, thank you. Now, my question is, who has the ultimate decision with regards to the methodology that is being used for the AOR delineation?
I think to meet the minimum federal stringency requirements, the definition really needs to remain in place, and additional conditions could be added to that.
Let me repeat my question.
Yeah.
So I'm asking, who has the final authority to determine which method, computational method, will be used for the AOR delineation?
Well, the reason I was being careful, and you've rephrased your question, is when you say to which method, there could be a method of like a 1/4 mile radius, and that would not be acceptable, and EPA, I would say, would make that decision in their primacy review. But if you are accepting the definition here in Exhibit 3, and
No, the modified one.
yes, Exhibit 3 definition, and you're using the term computational modeling, at that stage, what is an acceptable computational model? That decision would be the director of OCD.
Okay. So the director will have the ultimate decision to say that you are using EPA method 1, method 2, risk-based. Is that your response?
Yes.
Okay. Thank you.
Or another method that's not in the guidance.
Or another method that is not. Please explain that a little bit.
Well, guidance is guidance. It is, and it's not a requirement because it is guidance. And I would say the OCD director has the flexibility to accept other methodologies.
Okay. Now, so let's move to page 2, under G2. Page 2, G, under 2, G2, yes. You are defining geologic sequestration. Now, my question here is the last part of it. You said this term does not apply to carbon dioxide capture or transport. Why this distinction?
My understanding would be that it's because this rule and the federal class 6 rule do not have any bearing on capture or transport. So it's trying to be specific in usage of that term when it's used in the regulations, that it is for the storage component of carbon capture and transport and storage.
So you believe that still needs to be there?
I believe that's a helpful distinction in the definition.
Okay. Now I'll move to page 4. We've not discussed a lot about the USDW much. Now, let me ask, what you are proposing here, even this and together with all the other provisions under the USDW, is it following strictly under the EPA guidance and then also the waiver as well? I want you to put all of that together.
I'm sorry, do you mind rephrasing the question and maybe one part at a time?
Okay. Okay. So I'm looking at page 4.
Yes.
Section U, and then I'm looking at the underground source of drinking water. So you are defining what becomes USDW.
Yes.
So I'm asking you, did you follow strictly the EPA's guidance or you added to it?
I believe this is a copy, and I'll make the distinction of not of EPA guidance, but of the EPA regulations.
EPA regulations. Now, then let's take them one after the other, right there. So you are defining underground source of drinking water. Under 3, U3. So A, you are saying that which supplies any public water system, clearly understood. Number 2, which contains a sufficient quantity of groundwater to supply a public water system, and so that is a big, and then N, in addition to that, currently supplies drinking water for human consumption, or contains fewer than 10,000 TDS, right there, and which is not an exempted aquifer. And you go on to explain the exemptions. Now, if I can get to the exemptions. Let's see. Give me a second.
Yeah, the next page describes aquifer exemptions.
Okay, yes. So on page 5D. Now, so that one too, the exemptions, is it New Mexico specific or is all still EPA rule?
This is all still EPA rule, and even after receiving primacy, EPA still has jurisdiction on aquifer exemptions.
So do you believe that the way EPA really, the way the rule is structured, even with the exemptions, it gives more clarity to operators to really know what is the lowest, most USDW we're dealing with?
In my experience, that has typically been pretty clear. I think I have seen issues where the phrase contains a sufficient quantity of groundwater is subject to interpretation. I'm not familiar. There may be state level guidance that already covers that. I know other states have guidance that try to cover that issue.
So there's a way to quantify.
I would think through guidance.
Okay. Now, let's go back to 4 under the general provisions. So this will be 19.15, page 4, I meant, 19.15.48.8, A2. So you made a statement there, you're saying that such aquifers are those which otherwise qualify as underground source of drinking water to be protected, but which have no real potential to be used as drinking water source. Therefore, they are not USDWs. Can you explain that a little bit more?
Yeah, I think I would want to take a minute to read through
Sure.
the references above this. Yeah, I think that this is maybe an area that needs some clarity because I don't see really where it's defined that this is referencing specifically exempted aquifers. But I believe that's the idea of number 2 here. Where it says such aquifers, I don't think it's clear what that means. And it could be clarified to mean that. I believe it's referring to exempted aquifers.
It is.
Yes.
It is. And so you're saying that even though it could be a USDW, but have no real potential to be used as a drinking source of water. And I can give you an example. So like, let's say oil and gas bearing zone, it has TDS less than 10,000.
Yes.
EPA saying it's a USDW.
Yes.
Do you believe this is more or less clarifying those type of confusions?
This is a broader issue than just Class 6. Aquifer exemptions are available in other well classes. And in fact, EPA does not allow for an aquifer exemption only for Class 6. So if you were to provide additional clarity on this, I think it may be more prudent in guidance. And one reason I point to that is because EPA has jurisdiction on aquifer exemptions, even if you were to gain primacy. So I think it's really more of a EPA issue.
So then do you believe that this statement is clear enough? I mean, for anybody to read and understand as it is now?
Well, like I said, I was confused when it just started with such aquifers. So I do think it requires some clarity. I just think we would have to be careful in clarifying anything else in here because it's really an EPA issue.
Yeah, I do not have any suggestions here, but something to look into.
But your example, by the way, that may be the grounds for receiving an aquifer exemption under the Class 2 program. And so that is envisioned in the way aquifer exemptions are treated. And the only way to use an aquifer exemption in the Class 6 program is the expansion of an existing Class 2 aquifer exemption.
Okay. Now let's go to page 8. I'm looking at, so I'll start from page 7, the bottom of page 7. Looking at the transitioning from Class 2 to Class 6. Transitioning from Class 2 to Class 6. I'm looking at that one. I'll give a minute to make sure we are all there. So here, the way I understand it is that you are giving the director the room to more or less say, hey, you cannot continue Class 2, you have to move to Class 6.
Yes.
Okay. Now let's take them one after the other and see if it is clear in the rule that it's easy for the director to really follow that. So I'm looking at, so F is transitioning from class 2 to class 6, and I'll focus on 2, F2. The director shall determine when there is an increased risk to USDW compared to class 2 operations, and a class 6 permit is required. In order to make this determination, the director must consider the following. The first one is increase in reservoir pressure within the injection zone. Increase in reservoir pressure within the injection zone. What is the threshold here?
Yes, I believe we discussed this a little bit yesterday, and I agreed with you that this is an area where there could be more clarity in guidance. And EPA does not have very quantitative guidance on this list, so it may be something that would be state-specific.
So is OCD committing, so this one will be for Mr. Winkle, is OCD committing to provide clarity on this because it's a big deal? Now, we talked about the fact that there's probably no class 2 that can meet class 6, but with the class 2, with the class 6 provision, you see people going around, right? Mm-hmm. People going around. So would you commit to provide guidance to more or less support the director in making more meaningful and justful decision?
Yeah. One thing that we do try to do in any guidance that we author is set those thresholds and distribute those out for easier decision making, but they have to be scientifically bound, right? So
you made a good point about the scientific bound, and as an engineer, I'm thinking about what could be the bound here. I mean, this is a tough one, and I don't know because assuming, let's say, they are still injecting within the fracture pressure limit, but clearly that these guys are not really going for oil. They've turned it into a sequestration well. So how do you balance it? Because they are not really violating their permit because you've given them, let's say this is the injection pressure, or let's say the pressure that you have to operate. They are operating within that. So what triggers that?
I do think that this list kind of has to be looked at comprehensively, and I would point to number C, or letter C here, which also lists a decrease in reservoir production rates.
How do you
as you're saying that, they may always be injecting at the same rate, but they may, and that's a regulatory, but it's their discretion to decrease to almost zero, or just, you can see if there's a decrease, and that would lead to a larger reservoir pressure. So I would just take these in combination with each other in evaluating it.
And evaluate all of them. Yeah. But you do know that companies, even class 2 for enhanced oil recovery, they are getting tax credit. So if they are just injecting, and doing the economics, balancing it off. So there has to be more clarity as to how the director will say, no, you are really using it for tax credit purposes and not necessarily for enhanced oil recovery. So even the C, decrease in reservoir production rates. I mean, how does it become bad? Because as you know, even in a secondary recovery process, we intentionally continue to inject to build up our pressure to be the MMP before we start the CO2. And the production is still going to go down. So how do you even justify what will be the minimum rate to even trigger that?
I do agree with you that additional clarity and guidance will be helpful for operators on these.
And I can assure you I don't have any suggestion here.
Yeah, I do think it's achievable to have more detailed guidance on this.
Now, under G, still 2G, you made a point about the owners or operator plan for recovery of carbon dioxide and the cessation of injection. So can you explain that a little bit? Because probably an operator will not tell you right from the onset that I'm going to dump this and take that CO2 and take it somewhere, right? So how do you, and later on if they decide to do that, I mean, how are you going to square that?
I may actually kick this to Matt or Justin. I'm not familiar with what is required to be disclosed to the agency in a Class 2 program. But I think the intent of it was that economically in EOR, CO2 is a resource. So a true EOR project would try to recover CO2, whereas if the objective is long-term storage, the opposite would be true. But
I don't know if anybody wants to add to it.
Yeah, restate the question if you could.
So you have a provision here under 2G, you're saying that the owners or the operators plan for recovery of carbon dioxide at the cessation of injection. So I just want to understand the thoughts behind that provision.
And it's all based around the potential increased risk to USDWs and the director's analysis. I think it's fairly straightforward to me that if there is a change in plan or plan to stop injection, that the director must include that. So I don't know, Justin, you want to add anything?
I think I'm getting the point here. So you're saying that the operator has to let the director know whether at the end of the Class 2, because in the end of Class 2, or let's say for Class 2, the CO2 is a commodity and not necessarily a waste. So the operator has to let the director knows what they are thinking. Or let's say even in their application, they might probably have said, I'm going to take this CO2 and send it somewhere. So the director has to consider all of that before he says, okay, you have to go for Class 6.
Yeah, I would agree.
that's correct. I'm not aware of what you asked also in the same question, what they are required to disclose to OCD under the Class 2 program, and that I'm not aware of, so.
Okay. Now, let's look at page 8, still page 8. So I'm looking at 19.15.42.10, authorization of underground injection by rule. Now, so I'm reading through the existing Class 2 enhanced oil recovery and hydrocarbon storage wells, and I'm looking at last but one sentence, or is it the last sentence? You're saying that Class 2 enhanced recovery or hydrocarbon storage well that is authorized by rule. Such authorization shall terminate upon the effective date of a Class 6 permit issued in accordance with subsection F of 19.15.42.9 MMAC. Now, that provision, I'm thinking through that, is there some kind of a grace period for a Class 2 operator to still be injecting, saying I'm probably turning this one to a Class 6, or let's turn this one to be a long-term sequestration project? Is there a grace period there?
Well, first, I would just clarify that this only applies to Class 2 operations that were authorized by rule, not by permit. And I might ask, I don't know if that is a common practice in New Mexico.
That's what I was thinking. This is not a common practice in New Mexico to authorize an injection permit by rule.
So
they're authorized by permit.
Okay, so then why do we have that in the rule?
This would be something we want to go back and see if there is any, but I think if we were going to edit this, we would just add for clarity that there are none in New Mexico authorized by rule, but I wouldn't remove it, again, just because of EPA's stringency review. They would still, they just want to see that that is in there.
Okay, so for clarity, you probably have to look at it and see.
If that has never happened in New Mexico, I think it would be worthwhile to state that in this, and just for clarity.
Okay.
Can you elaborate, if I may jump in, can you elaborate on why that would be a stringency issue?
I think if we just remove this wholesale, because it's not an issue in New Mexico, EPA may look at it as we're removing a requirement.
Yeah, my thoughts would be in our calls we've had with EPA that they would like to see, they know that within the U.S. there are means of authorizing by rule, so they want to make sure we've covered that.
But if we simply don't allow that, wouldn't that be more stringent than what the EPA allows? How would that be less stringent than what the EPA allows if we simply refuse to allow it by rule?
I think we could ask EPA. But I think, first, I wouldn't want to know the answer. Have there ever been any Class 2 operations in New Mexico authorized by rule?
Understood.
And if there never have been, I think it would be good to coordinate with EPA on that.
Fair enough. Thank you.
Thank you.
Thank you, Director. Let me, I think I do have. Let me go through my suggested recommendations on the SB2 so we can move a little bit quickly here. And I do have probably, so I'll go to number 6 of my suggested amendments. And I'll look at page 4 of the Exhibit 1. Page 4 of Exhibit 1. Let me see. Oh, Exhibit 2, sorry, Exhibit 2. Page 4 of Exhibit 2, so give me a second. Now, this one, let me see. So I'm looking at 19.15.42.8. Now, this is a general provision. And for number 6, I am looking at, do you think it will be necessary to put in the rule that you are actually more or less following the EPA guidance? So that is what this suggestion is about.
I have a little hesitation on that, and it's because of thinking of the whole universe of possible future conditions, and there may be a time in the future, although I largely agree with the EPA guidance documents now, there may be a condition in the future where EPA were to revoke a guidance or edit a guidance in a way that OCD would not necessarily agree with. Although this is written to be flexible, my hesitation would be just that.
Okay, then look at my number 7 too, and combine both of them.
I would say I would defer to OCD on whether or not these add additional clarity, but to taken together, or if the additional framework already provides these provisions, I would definitely defer to you and to OCD.
Okay. Mr. Renkel, do you have any feedback on this? Or you can take it back and then at least I want to know what OCD thinks about it.
Yeah, and you're referring to number 7.
So I'm combining 6 and 7.
6 and 7,
Yeah.
okay. I think Jesse's taken some notes there that we can go discuss and then come back. But no, I get Dr. Schnarr's point.
I appreciate that. Then I'll switch to the last exhibit. So that'll be OCD exhibit number 3, and that'll be my last one. And I'll wrap up soon. And I'm going to start with page 4 of exhibit number 3, and I'm looking at number 12. So there you are defining transmissive fault or fracture. And you're saying that means a fault or fracture that has sufficient permeability and vertical extent to which allows to move fluids to move between formations. So my question is the permeability the technical word or transmissibility is the technical word here? I do see the fracture in there, but I still want to ask though.
The question is whether or not it's permeability or transmissibility.
Yes.
I think permeability is sufficient, but I'm open to additions or edits or red lines to clarify this.
So from your point of view, at least it gives clarity to the layman who doesn't know what transmissibility is. So you believe the permeability is still okay?
To your point, if this was really framed more to layman, I would add more language after this sentence to provide additional clarity to a layman.
Because I do, so you go further to describe how the faults, fractures should be implemented in the, let's say, in the models and all of that. And when you are saying permeability, I mean, the permeability is part of the calculation of the transmissibility. The transmissibility is the key here. And I'm not sure if we are using permeability, which is an input in calculating the transmissibility, we are really covering it all. That is just my point here.
I think it's reasonable to provide additional definition. I think this is, just to be clear, this definition is used, it's an important definition because the confining zone must be free of transmissive faults and fractures. And that's a very key part of the site characterization. So.
That is where I'm coming from. Because if you do say permeability and you do not use transmissibility, transmissibility is what goes into the model, not permeability. For the fault.
Yes, I think it would be fair to add additional context and definition here.
Okay, that one I do not have a suggestion for you, but something to look into.
Okay, thank you.
Okay. Now let's go to page 5. And I'm looking at page 5, That is talking about a stimulation program. And I'm pretty sure you probably sense what I'm going to ask. So if operator doesn't provide a stimulation plan and the director completes all the reviews, can they come back?
In my experience with EPA, it is not a strict requirement to have a stimulation plan, but the director strongly encourages it because in the future, if some minor stimulation is needed, it would be, in their mind, a major permit modification to then, at that point, add a stimulation plan. So they, in my experience, the different EPA regions really stress, and actually, there's been more recent guidance in the last few months from EPA essentially telling operators that it's a weakness of an application if it does not include a stimulation plan.
And New Mexico will also follow that.
Yes, and also there might be, we could look into any clarifications to put into rule on that as well.
Okay, thank you. Now, so let's go to number 6, page 6. And I'm looking at number 2, page 6, and I'm looking at number 2. Give you a minute here. So you're saying that the director shall notify in writing any states, tribes, territories within the area of review of the Class 6 project based on information provided in subparagraphs B and T of paragraph 1 of this subsection of the permit application pursuant to the requirement of section, and you state that you reference that. Is there any timeline on this, or it is left to the discretion of the director to determine at what point does he feel like I need to notify these agencies or groups?
So basically, you're saying that there could be a threshold deadline here, right? Basically within X amount of time. The director, yeah, I think OCD is open to that.
Okay. And I do not have any suggestion on that one, but I thought there has to be some clarity on that.
Well, yeah, it would make it easier for us, especially. I think that we can go back and talk to the relevant individuals and see, you know, what a practical time frame would make sense there.
Thank you. I appreciate that. Let's go to page 7E. That is the area of review and corrective action. Page 7, paragraph E, and there you define the area of review. Now, my question is, can aerial reviews overlap?
I have not seen that yet, but I don't believe there's anything that would say that can't happen.
So in the event that it happens, how is the coordination going to be like?
Both operators would be subject to the rules within their area of review.
So you said it can happen. Do you believe that an operator can challenge a potential aerial review overlap? And what would be the suggestion to, let's say, OCD? As we are, I don't know if OCD has thought through that.
I would defer to the other panelists on sort of the ability of other operators to.
Yeah, the question for you is, so the question, is it around 2 new permits in beginning stages, or 1 existing permit in 1 existing location and then a secondary coming in?
You made it even much clearer for me, because you do have project A and then project B. Now you brought in the time. Which is key here. So I'm asking, the operator is going to submit to you the entire AOR to the end of the project. Operator B is going to do the same thing. And I'm asking, if OCD is reviewing this application, and there could be one, could there be, or let's say, can OCD accept overlap of AORs, 2 different projects?
I believe in the permitting process, either one of those parties would have to consider the maximum interference from area wells that would be injecting in the same zone, if we're talking the same formation. And if they don't have, well, if there's one that's moving forward and going to permitting, then that operator A won't know what's happening with operator B until the permit is issued. So the only mechanism in place there would be the opportunity to protest that you've been notified, as either operator notified of plans and have the ability to protest the plans that are in conflict with another operator's plans.
I'll just chime in real quick that it is looked at, and particularly in the EPA implementation manual, that this is a key function of the primacy entity, is to evaluate potential overlap in projects and make sure that these projects that are in the near vicinity of each other are considering the pressure effects from the other projects.
Yeah, the pressure effect is key. Now I'm company B coming in, company A is there. I use company A's area of review. I do my modeling. He's putting in 50 million. I can put in 50 million. Remember, there are some operators that try to use this area of review to capture pore space. I don't know if you've heard about BLM trying to make sure they control how they give their lands to sequestration projects. So company A can come in and tell you, I'm going to inject 50 million metric tons with a big AOR. It could be that the objective is not actually to really inject, but to capture that pore space for future ransom, right? So operator will come in. Operator A already have a permit. Operator B is coming in. Done all the models. I can inject, even in the presence of operator A. We do have overlap of the AOR. Do you believe that just the overlap of the AOR can give OCD the authority the operator protects to deny the permit?
Yes, I think it can, because the secondary operator would have to consider the pressure fronts and all the information in that existing permit for operator A. One thing we did do, and we commented on earlier, is maintain the expiration to 2 years. So if there is someone trying to do what you're talking about, it would expire and they would not have good reason to ask for an extension.
You got me right there. But let me ask, definitely during your outreach, the operators that are injecting saltwater disposals probably might have hinted you, hope you are not coming to take over our pore space. I don't know if that discussion came through or not, but how is OCD going to value CO2 sequestration and then water injection all into the same zone? Has there been any discussions on that?
There has been, because we have we have experience in these situations, and the discussions internally within, the operational team has been to supply very specific guidance for certain scenarios. Two new overlapping that are both brand new, existing overlapping, and how the applicant should navigate those via OCD guidance. Now, again, those haven't been developed yet, but there has been conversations because of past experiences in other classes.
Now, since you said you've been discussing this, do you believe that saltwater injection and CO2 injection can coexist in the same formation?
Being a layman, I don't have an opinion on that. I would have to refer to a technical team.
I can speak to that.
Yeah.
Yes, it can coexist in the same formation.
So then existing saltwater injection company cannot necessarily use that as an excuse to more or less protest against, let's say, a sequestration project.
Yeah, so if any company that would be affected, again, has the opportunity to be notified and protest, and the applicant has to include the total maximum permitted volumes and pressures allowable for that SWD company in their calculations to determine their total permitted volumes and pressures themselves.
Now, let me ask you, who bears the burden when there is that kind of, let's say, if someone protests, who bears the burden? Is it on both, or is on the new company coming in?
It is on both.
Okay. Thank you. And so if I go to page 12, we've already talked about that, and I do have some suggestions there with regards to the casing, the surface casing, and then the long strings. I do have a suggestion that we will go through. But before that, let's go to page 13. I'm looking at page 13. I'm looking at 2A, and that is a list of the locks. Now, Oxy also brought this one up. So I'm asking you, do you believe that there has to be or for the spontaneous potential, or you still want to keep it right there as a requirement?
My recommendation on this issue would be to take this question to EPA.
Okay, to take it to EPA.
Yeah.
Okay. Thank you.
That's just my recommendation.
Yeah, and I would add to that, in following the question yesterday, spontaneous potential works in water zones, and it's that more or less a voltmeter. So it wouldn't cause damage to the formation, but it would essentially not work in an air environment.
Exactly.
And
if you are using oil-based mud.
Correct. It's not very useful in oil-based mud. So we can take that to EPA, but my interpretation of this is these are tools that would be a minimum if valuable, but we'll just have to ask EPA how to term that. But just taking it out, especially for surface casing, which you're looking for water, it's good to have that in as a minimum.
Just a suggestion, if you have more comments.
No, I do have, but we can.
But we can break and come back. Okay. Sure. Let's take a mid-morning break for everybody's comfort.
All right.
Thank
you. Let's come back at 10:45.
That way you don't.
Let's come back from the break, please. Let's see. And we need one more witness, I think, yes? Oh, there he is. All right, we are still cross-examining the second division panel. Commissioner Ampoma, you have more questions.
Yes, I do. So I'll go to page 13. Page 13 of exhibit number 3, exhibit 3 of OCD. And I'm looking at number 3. That will be, is it H3? H3. Now in here, you're talking about the fact that the operator, the owner or the operator must take whole calls or sidewall calls. Now, I want to ask, which one takes precedence over the other? Because you're saying must, it means they have to, but you're saying whole call or side call. So which one takes precedence over the other?
Yeah, I would say whole core would take precedent over the side core, just for better quality.
So then with that, will it not be possible to really clarify that? Because there are instances where operators will start with whole call and you cannot recover anything, right? So then they do have a sidewalk call right there on site to really use. So is it possible to clarify, to see which one takes precedence over the other?
So Commissioner, we'll go look and see if this was part of the and/or situation that, the CFRs allowed and we didn't. And we'll take under advisement to see, which one has precedent.
Yeah, and definitely, okay. But definitely it will not be end.
I think what you're saying is, so it requires core, one or the other, and which order of priority do you first use? So in normal circumstance, you would try whole, but if you have trouble with that, you would go to side core, sidewall.
Commissioner, just to make sure I'm tracking with you, could you repeat which section you're on for me so I can track?
Yeah, so Chair, I'm looking at OCD Exhibit 3, page 13. Yeah, section H, 3. So yeah, page 13, H3. Okay.
Thank you.
Thank you. So some clarification on that would be really helpful. But if we go down the same session, you're talking about the director may accept information on calls from nearby wells if the owner or operator can demonstrate that call retrieval is not possible and that such calls are representative of conditions at the well. My question is, what will be, is there more like a distance that the director can consider? Is it 100 feet, 100 miles, 200 miles? So if that could be clarified.
Well, to start on mine, I think it's a good question, but it's a difficult one to answer just because of how some areas have large homogeneous areas for miles and some are going to vary. And so I think it needs to be up to the discretion of the director of the OCD UIC group on what they would accept.
But you need to give some guidance to the director. So let's think about, before they can make that claim, have they compared the logs? In those areas, because you're talking about homogeneous nature of the formation, right? But there has to be some guidance to the director.
I think the guidance is a good recommendation. I do think that is in practice today as far as what's understood to be homogeneous through the permitting process and what needs to have logs closer for permitting. So it's a good idea for a guidance document.
You know, this provision is also something that the director can use to require strat well or not. Because operators can say, oh, there's a core 50 miles away from here. I have everything that I need. So the question really is, at what point will the director has to request a strat well before, let's say, the initial application can even be deemed as complete?
I really feel that's a project-specific determination. And in my experience, a strat well is necessary when there is not a lot of previous oil and gas or injection activity, so there really is no existing well data. But in areas with a lot of existing well data, it may not be necessary.
Okay, but you are using the word must here. You're saying the owner or operator must take a whole core. And as you said, let's say I'm just going to use the San Juan Basin as an example. There are a lot of well data, meaning logs, everywhere, but not too many core that penetrates the potential injection zones there. Now, operators can use that and then avoid, because the only thing that the operator will need to drill a well for will be the core. Aside the core, all logs, I mean, it's all really available, but you are using the must. You are using must here.
Well, I'm looking at the language just to make sure I understand. I think this is specifying from the actual injection well. We'd have to back up. Yeah, it says logging, sampling, and testing prior to injection well operation. My understanding is that these requirements would be from the injection well.
So this one will not be applicable to the permit to construct, but the permit to inject.
The operator would have to have a plan in their initial permit to collect these cores. That would be part of the permit to construct. And the authorization to inject would be dependent on their final submission of the well logging and coring data and results to the director.
So are you saying that it could be at the discretion of the director, assuming they couldn't recover the core, even though you are saying it's a must, right? But they couldn't recover the core in the injection zone?
I think that this this text provides enough flexibility to the director to allow for them to not take core if it was not feasible.
Okay, so let me wrap it up and let's go through some of the suggestions that I do have for your consideration. So I'm going to start with page 7 of Exhibit 3 of OCD. And I'm going to look at, so 19.15.43.9, E3. So in the, you're still all we're concentrating on the area of review. Now, I do have some suggestions that I really want you to read through that. So that is on the screen too, because we've discussed a lot about model assumptions. I do know that you can clearly say, okay, yeah, I'll probably go into the guidance, but you listed some of it in here. So I feel like this one, we have to consider this. And the 4 and then the 3, model documentation, and then also the sensitivity uncertainty analysis, they are all together. So if you can review my number 3 and then my number 4 to see if any of them, if you agree that we should add this to the rule or probably belong somewhere else.
I would just ask for a minute to
Sure.
Question for you on just the order. So 3A, there's a sub I, 1, 2, and 3. And then this one is jumping to 5 and...
No, start with 4.
Okay.
Yeah, so look at on the screen, so you see number 4, we're starting with 4, so it will be an addition to that.
I think that these edits are potentially helpful to provide additional clarity on what is required for model documentation. And I don't think it really would add much additional burden because most operators should be doing these things.
I appreciate that because if you look at it, there's a vast range of things that operators have options to do, right? But I do feel like with these, we are narrowing it down. So if you can consider, but I do appreciate the feedback. So if you can consider and then see if you will agree with me on this.
Yeah, I can see from reading through this that it's definitely very thought through how this would fit into the existing structure. And I think that it would, these are good suggestions.
I appreciate that. Then I'll go to the last one. The last one. And the last one, let's think through it in terms of you want your, the rule that you are putting up, you want it to be more stringent than the EPA. So let's look at this one. So I'm looking at page 12, and we discussed a little bit on this one, so I'm not going to read anything here. So I'm looking at B and C, and I want you to look at my proposed language here in addition to that and see if you will agree to it. That will be number 5 on my suggestion.
And I could speak to that one. Hear your point on, in my mind, the potential of it being more protective. On this one, after our discussion yesterday, what it really brought home to me and thinking about it last night is just the value, again, of the state having primacy, because the OCD UIC group is so familiar, decades of experience with different formations. The area that I work in, Siluro Devonian in the Delaware, all wells are completed open holes in the Siluro Devonian Delaware for a number of reasons. One of them being the depth, 18, 19, 20,000 foot, and that the open hole zone stays open. So there's, and I don't know the numbers, we can research this. I believe there's dozens of wells permitted Siluro Devonian open hole. But I also know from experience that the OCD UIC engineering group would require cased hole in some other zones like the Bell or the Cherry, where they want to see that structure. And then, as was mentioned yesterday in the San Juan, likely other formations require that to be more robust. So it leads me to, my thought would be, if the director was called upon every time a permit came forward in the Delaware, in the area I'm familiar with, there would be a continual request to have the director approve not doing cased hole in order to minimize the risk of running casing to the bottom of the Siluro Devonian to 20,000 foot, and the risk that comes along with that and getting stuck or having mechanical problems versus the benefit, again, in my opinion, the minimal benefit of casing to that depth. And I think it would be a recurring question. So my thought would be maybe to adjust the language to UIC engineering manager or UIC engineer rather than director.
I'm good with that.
Yeah, and I think when we're saying director in these roles or his or her designee, right? So I think that would fall upon the UIC manager. So I agree totally with what Matt's saying. There are instances where, you know, open hole versus cased hole is accepted. I do think that either in guidance or either in the actual rule, that there could be explanation on what would be acceptable, you know, the different parameters of the formation that you're injecting into, where we would potentially allow open hole, and then describe at a high level where we would definitely not, where there was issues of clay slippage and whatnot.
May I quickly jump in here? I heard you use the word designee. I looked in the definition of director in a few of these places, and out of purely altruistic concern for future hypothetical directors.
Understandable.
I don't actually see that in here, and at least not in the definitions portions. And in fact, there's a couple of places where the director is referred to in the singular his or her capacity. So I'm wondering whether that might be something we could add to the definitions to clarify that when director is used throughout the provisions here, that we're referring to slightly broader than the singular person.
Chair Chang, if I may, I think this is something that we can address in closing, and we also want to look closely at and explain how this would work in implementation in comparison with other rules that reference the statute and the rules reference director. There's a normal practice for that. But understanding, I want to make these future hypothetical directors' lives easier. So I would like to address that in closing.
Sounds good.
Perhaps address the definition, but we can take that under advisement.
I just wanted to put that on this, flag that, because in certain other NMACs, for example, it will specifically say the director is defined as the director and or his designee. So anyway, just wanted to flag that might maybe a little massaging of the or wordsmithing of that definition might be helpful.
If I can interject, are you referring to, so I'm looking in Exhibit 2 on page 1. In D, director is defined, means the director of the New Mexico Energy, Minerals, and Natural Resources Department, Oil Conservation Division. So are you suggesting that we add or designee?
I don't want to put specific words in your mouth, but I know that I think in the mining, in the NMAX for mining, that's how the director is defined, is comma or designee.
Or designee.
I don't know if authorized representative, staff, there's a potential range of terms that might best capture, so we don't end up with a receptionist, for example, acting on behalf of the director, right? But so I'm not suggesting any particular words, but yes, but along those lines, somewhere of clarifying that the director is not maybe slightly broader than as currently defined. Thank you.
Yeah, so will you respond to my suggestion?
Yeah. I'm sorry. I thought I did. I think that we're still talking about case toll and non-case toll, correct?
Yes.
Okay. Yeah. I think either in guidance or outlined in the rule would help both sides determine in their pre-construction permit, deciding, if they're going to run casing that long, or, if we wouldn't even consider an open hole.
Yeah, I do feel like it has to be in the rule, because I had last night I'm just looking at, class 2 was cased. Why is UICs do have that preference? So if you can look at it and see if we can add it to the Exhibit 3, that would be good. But just look into it.
Yeah,
my only
definitely.
thought, let's kind of interject here. My only thought is that the class 2s I'm familiar with are not cased. And again, it's just the formational differences. Some are that are in shallow zones. And so the concern I would have in getting very specific in rule would be you could sort of do the same thing on all casing layers and all strengths and tensiles and things in rule, which constrains the OCD by doing that. I do think that maybe something along the lines of guidance. I think putting it in there, and also if I was the OCD UIC engineer manager and I was starting at all times with, I had to have a case toll in the slurred Devonian, again, the one I'm thinking of, in all applications. And then I put my neck out there and I say, in this one, I say it's less risky to do it non-case and it's viable. It would put me in a strange spot versus just allowing the language which is in here right now, stating that the operator must consider all formations, integrity, and strengths tensiles that are necessary for that project specific application. So I would hesitate to just go to one particular area, requiring it by rule versus getting it in guidance. I think it's a good place in guidance to say it should be considered strongly. But I think in rule, it just sets a precedent that would be hard to back down on. And it's going to happen multiple times to back down from it.
Yeah, so if you can look at it or even or suggest a different language, that's fine too. But I really want to know before we start discussing. Mr. Winkle, this will be the last question I have for the entire panel. You know, I must say that as a commissioner, I'm encouraged to see the many experts that are supporting the rulemaking are actually from New Mexico. You know, either working in New Mexico, you know, let's say living in New Mexico. I mean, was that intentional effort by OCD to build a New Mexico-based technical team for this important primacy application? And what does that benefit to that provide to the state over the long term?
So I think, you know, we have to be fair of who we contract with, but we can impose different values on experience, right? And I believe I touched on this a little bit yesterday, but with New Mexico being unique, very unique geology, that's going to have more weight than, say, other things. There's other aspects in our daily life that we would like to migrate more into New Mexico, like on our seismic response areas, consulting, you know, keep it within New Mexico. But yeah, from the get-go, the start of this, it was, you know, who has the best knowledge of Permian and San Juan geology and experience with injection, and it landed right in New Mexico, which future MOAs that are part of the Class 6 are the weight of that experience. Local New Mexico will be higher than other parts in a RFI.
I appreciate your long time that I've spent with you, but it's been very fruitful. So thank you to the panel, and I appreciate all the effort to support this application. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Mpoma. Commissioner Ostrowski, do you have questions of the panel?
Yes, I do. Thank you for your time. I appreciate it. I kind of just want to start off with, I'm just curious, yesterday in the testimony, someone mentioned that there's already a Class 6 permit through the EPA in New Mexico. Can you explain that a little bit? Who is it? Where is it? Just a little bit of background and what stage of the process it's in?
I'll just clarify that it's not actually a permit, it's a permit application.
Okay, thank you.
I have a little bit of knowledge about it. I'm not sure if you all have more. I know the operator is Tallgrass. I don't have a lot of additional background.
I don't either, other than to say, as far as I know, it's an application in process also.
Okay, thanks. Oh, did you have something to say?
No, I was just going to add to that my potential UIC team have been talking with EPA, but we haven't shared any information yet on that potential application. Yeah.
So what will happen if New Mexico gets Class 6 primacy? Will that go to the OCD then, or will it stay with the EPA?
Do you want me to answer?
Yeah, go ahead.
In our conversations with EPA, they explained how they have gone through this in the past with Texas and Louisiana, and they essentially, if the application is still in some stage of review, they will provide like a briefing package of their review of that application to, in this case, OCD, and then OCD would take over the review at that stage.
And would they get all of the material that was submitted to the EPA, all the models and everything?
Yes, thank you. Yeah, for clarifying. Yes, that in addition to this kind of briefing package on their review.
Okay, thank you. I was just curious how that process worked. So I think I'm going to go a little bit opposite of Commissioner Mpoma. I'm going to go through the rules and some definition questions, and then kind of go into my broader questions after, if that works for everybody. So let's start with Exhibit 1, so Part 41. And my first question is, in G, definitions beginning with the letter G on page 2, from the definition for geologic sequestration. And I'm wondering if the phrase long-term containment is a little broad and could be defined better.
I'm sure there's always room for improvement, but maybe I don't know if you could provide a little more detail on how you would like to have that additionally clarified.
Well, long-term doesn't really say how long. Would that be permanently? Would that be 50 years? Would that be 200 years? I'm just wondering if there could be any clarity on that.
I'll definitely take that under consideration. Thank you.
Okay, thank you. Okay, my next question is on page 3, and it is the definition for owner or operator. And I'm wondering if there could be any clarification here with the words owner or operator. I think it might be kind of confusing to the general public. An operator is usually somebody who operates on operates the well, where the owner could be, it could be the landowner, it could be, you know, the owner of a facility. I'm just wondering if there could be any clarification, either separate them out into two different definitions, or, and this repeats through the, I think it's in every definition, and throughout the rules, it'll say owner or operator. So I think it might be nice to clarify that. Do you think that's possible?
Yeah, my suggestion would be to keep the existing text and then add to it some additional clarification to meet your request.
Is this definition come from the EPA?
Yes.
Okay, so would it be possible to clarify it, or?
I think so. I think you could keep the existing text and then potentially add one or two sentences after it to provide that clarity on the distinction between an owner and an operator.
Okay. And then throughout the document or throughout the rule, would you change it to be owner or operator to be just operator, or to help clarify that?
I think that I would keep that the same, just to reduce any back and forth with EPA on this topic, and that both entities are regulated. It's just how they viewed this in the past. It may be a legal question that I can't speak to, but I just know that's how they've always framed everything that I've ever done.
And I know I'm reading here that it says there's the one subject to regulation under the UIC program, which would only be one entity that would be subject to regulation, I would think, but I don't know, maybe more clarity on top of that.
I recall us looking at this particular definition, and I think Matt is right, is the last sentence of that. I think we were okay with that because it identifies whoever is responsible, but point taken, and I think we can take a look at that and give a little bit more clarity, because for the public and laymen, it can probably look a little confusing.
Yeah, thank you. And kind of along those lines, I've noticed in some parts of the rule, it'll say permittee and instead of operator owner, and I'm wondering if that should be further clarified, or one or the other should be used in all cases.
Yeah, we can also take a look at that as well.
Okay, thank you. And just further down on page 3, under the definitions, beginning with the letter S, I think this might just be a typo, but I see subsurface fluid distribution system. Should that be a separate definition?
I noticed that as well. I believe you're right. That should be formatted differently.
Okay, thank you. And then jumping back up to the definition of person, that includes, multiple entities, but including the federal agencies. And I'm just wondering if that conflicts with, on page 4, A1, it'll say any person who requires a permit under the UIC programs. And if a if a project would happen completely on federal estate, would they need to apply for a permit through this?
So I don't, just by looking at it briefly, I don't think that that definition contradicts this, because I think any of those, the listed out individuals can apply for a permit. And yeah, for primacy, it would be the entire state, even the federal area, just like our normal UIC program. But I can triple check that for you to make sure that that is the case.
Okay, so if it was a completely on federal land, they would have to go through the OCD and not through the EPA?
Yes, other than tribal lands.
Okay. Also, with the definition of person, I was wondering if that could include limited partnerships, limited liability, limited partnerships, and limited liability companies for completeness.
Yeah, we can definitely look into that as well.
Okay, thank you.
Commissioner, may I ask, is that, we've gotten proposed edits in prior rules or comments from the State Land Office, so is that intended to mirror language that's referenced before? I'm just looking for source language to incorporate for our team's review. If there's a specific example, I would go back to that. But if it's new language,
I don't believe it's new language, but let me double check where that comes from.
Okay.
That's okay.
And
I just want to make sure we use the precise language. I know there's particular types of partnerships that have been concerned to the State Land Office.
Okay, yeah, thank you. I appreciate that.
Just for my clarification, you're asking to specify, we were asking whether it would be a good idea to specify specific types of partnerships? Is that what's going?
Yeah, just to include that into the definition, because those should be able to apply for.
Well, of course, but they would like a limited liability corporation is a corporation, right?
I believe that language comes from another, I'll have to double check.
Okay.
I think that was the question I have, is it lists partnership and corporations, so you're asking to, like, parentheses of all types of partnerships and all types of corporations, or are the general terms in the guidance acceptable?
I think it needs a little bit more clarification, a little bit more detail.
If I may, it may, since this is a more broad term referring to partnership in a general sense, making a specific partnership might limit the stringency here, and that might be a stringency concern with EPA.
Okay, but I mean, it seems like there's some areas where we're adding extra. So with this, if we added this extra in, would that really?
If I may, we'll take a look. I believe I may know where that other language is from, and so I agree with the kind of question underlying the chair's question and the concerns with lists. When you list things out, can become considered exhaustive, so we just have to wordsmith that. And I want to make sure the language mirrors. I don't know where we'll land. I need to be able to talk to the team about that, but we can go back to the other rule and see. But to Dr. Schnarr's point earlier, I think adding clarifications in and making sure it's not exhaustive is probably the appropriate drafting approach there. I don't know if it's necessary, and we'll have to speak at length about potential stringency.
Okay, thank you. Let's see. So also in this, let's see. So in H of this, Exhibit 1 on page 7. And I have a question about the term drilling operations. So it says, if drilling operations have not commenced within the 2-year period, the permit shall automatically terminate. And there have been cases where a company might drill, 15 feet and say, we're having ongoing drilling operations. I was wondering if this drilling operations could be further defined to help prevent that from happening.
I think we're just having trouble following where you are in the regulation.
Page 7 and H, issuance and effective date of permit, and number 2.
Excellent, thank you.
Yeah.
So just reading through it real quick. Yeah, I don't see an issue with further defining that with, I believe in other areas in our MNAC or in internal policy, we have said breaking ground with intent to reach bottom. But, I think we can wordsmith that to where, you don't go and drill your first string and then you can then wait 5 years. So that's a good observation. I think we need to distinguish that.
Okay, sounds good. Sorry, I have so many papers up here. So let's look at Exhibit 2, which is Part 42 now. And first, I would like to start with 12A5, which is on page... on page 12.
Okay.
And in this section, it says proper operation and maintenance includes effective performance, adequate funding, adequate operator staffing and training, and adequate laboratory and process controls, including appropriate quality assurance procedures. I'm wondering if that could be better defined and who determines if something is adequate.
No, I was going to you. I was talking to you. Yeah.
I can only probably speak to the very last one, which is the quality assurance procedures, but your question is broader than that.
I mean, you could answer that for now.
There is a quality assurance plan that is required to be a part of the permit application that is a condition of the permit and does define in very detailed what the quality assurance procedures are for all of the monitoring for the project.
But do you think that should be more guidance in the rule instead of in the permit itself?
I think on this topic, I would probably defer to my other panelists or the OCC.
So operate and maintain, are you suggesting maybe just a little bit more elaboration on, their equipment operations, maintenance records, laboratory calibrations, that it would actually be spelled out in the rule rather than what we review internally?
Yeah, I'm just wondering, adequate seems very broad.
Okay.
I'm wondering if it'd be better to do a little bit more clarification.
I think one thing is there could be reference added to the requirement for the quality assurance plan. So that's something we would have to go back and look at, but that is one way of addressing at least part of this.
Okay, thank you.
Could I follow up with a clarification if you don't mind, Commissioner?
Yes.
These, and correct me if I'm wrong, panelists, but these are general conditions that are applicable to all permits. They're not an exhaustive list of conditions, right? So the idea is, to the extent that we need to look at case, or that the division would eventually be looking at case-specific applications of these broad principles, there would be specific permit conditions specific to individual permits that would elaborate on what that means, on what these more general terms mean in each particular permit on a case-by-case basis. Is that the general gist of what these general conditions are meant to accomplish?
That is normally the case, Commissioner, yes.
Okay, so let's see, on page 14, number 15. So the sentence, for purposes of this paragraph, temporary or intermittent cessation of injection operations is not abandonment. And this is an area that I also think could be defined better. What do you think that this area could be, have a time limit rather than having it be open-ended?
Yeah, just one second. I'll go look at the citation that it references to see what the context is.
Okay, thanks.
You have it.
Yeah, it starts on page 3 of Exhibit 3. And this is really the kind of technical standards of all of it.
And are you just, Commissioner, are you just referring to the last sentence in 15 there? For purposes of this paragraph, temporary or intermittent cessation of injection operations is not abandonment?
Yeah, I think having more, I'm just wondering if that could leave it to be open-ended to avoid having wells not injecting or not being plugged for a long time.
Okay, so maybe a holistic view of how long cessation takes place.
Yes, I
or
think.
Can take place, excuse me.
Yeah, would that be able to be considered?
I think we can look at that broadly. I don't know if that would fit specifically in this, but there might be an area where that could be fit into. I would be looking more for, just thinking ahead would be, limits on basically what we're calling downtime, right? And justification to go beyond that limit, right, to the OCD. So we can definitely take a look at that.
And I could speak to the Class 2 program, and in that program, an operator is required to initiate injection within 12 months, or they lose the permit. So we could look at how that might be something applicable with this too.
And would it be possible to add in language to limit the amount of time a well would be not actively injecting?
It may, we'll have to do some internal discussion, but it may fall under the inactive well rule already. So that may be covered, but if not, then we can look at maybe some rule additions or clarification to make that distinction.
And what I would add would be that, in my opinion, the rule was set at 12 months primarily to allow workovers, some things that may take some time to get the well back into, operating shape with integrity. So that allows that amount of time and considering material availability. But Justin had the best answer.
One other thing I'd like to ask about is, it seems there are a few places in the rule that have the text administrator, and I'm wondering if that needs to be clarified to be director or maybe EPA administrator. I don't know if you could add any clarification on that within the rule.
Yeah, I think that is a good idea to do a word search, but there may be instances where it actually still needs to remain the EPA administrator, like in reference to aquifer exemptions or something like that. But I think it certainly could probably use a sweep and just make sure.
Thank you. So on Part 43, which is Exhibit 3, and on the first page for the definition of abandoned well, I'm wondering if the term permanently discontinued could be better defined. Would this allow an operator to not plug a well for, a long time? Like,
I'll just clarify. I think one way this term is used is in the search during corrective action that you need to search for abandoned wells. So it may not be something that is under the direct control of the operator.
okay. And number 5 for the definition of confining zone. The way it currently reads is that limiting fluid movement above an injection zone. Would that be possible to change that to out of injection zone?
Yeah, I'm giving that some thought. I'm spinning through it. I don't think that would be a problem.
I think that would,
Take that under consideration.
Okay.
yeah, I would agree. I think it's worth considering.
Okay.
So that's considering both the top and the bottom confinement zone.
Yes.
Well, that is
Or-
the clarification that I was kind of mulling over in my head. The Class 6 rules actually don't have a requirement in all cases for a lower confining zone. But the way you phrased it, I thought was fine. But just to be clear, the base requirements are for there to be a confining zone above the injection zone. And then in cases where you are injecting between or above the lowermost USDW, to have a lower confining zone.
Thank you.
And I could just add from Class 2 experience that OCD does expect a confining zone on the top and the bottom in the application.
Thank you for
So
that
I think the
clarification.
language is good.
And for, again, with the confining zone, so on this page, number 5, and then there's another definition in 9B4, which is on page 4, number 4. And I'm just wondering why those are different.
Which definition again?
For confining zone. There's one definition on page 4 and then the other one on page 1.
I believe that the reason why this is structured this way is because it mirrors the federal rules, and the federal rules are written sort of organized a little bit differently. And that's where this different definitions of area review issue came in. And 43.7 is probably broader, and 43.9, which I think is at page, starting at page 4 or page 3, is really what's specific to Class 6. But my understanding, these rules really are only for Class 6. And so my suggestion would be to consider taking the definition, which I like better, on page 4, and just using that, or and removing that issue. So either having the definition once or replacing the definition in the first part to be identical to where it is in the second part. And the definition on page 4 kind of covers this issue of injection depth waivers that I was speaking to earlier.
Okay, thank you for taking that under consideration.
May I follow up? Because that's a really good question. It seems to me you're looking at the applicability here. You've got a definition for the same term, right? Confining zone. You've got a definition under 1915 43.7 that's applicable to the entire part. But then you have a different definition as written here that is only applicable to 1915 43.9b, right? Because at the top of page 4 there it says the following definitions apply to this subpart.
Yeah, that's what I was saying.
So that's a very unusual structure in our NMAX to have the same term but used differently with it. I mean, it's not unusual for the same term to be defined differently in different acts or even different sections of the NMAC. But that is pretty unusual to have two different sets of and then not just one, but two different sets of definitions. One that only applies to a subpart of an NMAC. So, I don't know whether or not there's a good reason to do it that way, but you might want to help us understand why it's structured that way at some point prior to closing.
If I may, we'll take that under advisement, Mr. Chair, but I just wanted to note that the reconciling the CFR into the state legislative drafting, there are certain sections at the beginning of each part that are required, including definitions. So where in the CFR you may have two different types of applicability of a term, we have to incorporate that in the definition section and then the applicability section. So I'm not giving you a final answer, but there is a good reason for it. We're reconciling a very dense CFR with very anachronistic legislative drafting. And that's the reason, and the reason I'm interjecting is because that direction came from out of consultation with state records and through legal and not from the technical team.
Oh, no, I understand. Yeah, and I know the technical team probably can't answer the exact, but that's why I'm saying at some point before closing, I think it would be fair and would be helpful to both for all of us up here to understand, because that is relatively unusual structure for an NMAC. Thank you for allowing me to interrupt.
No, thank you. I appreciate your input. Okay, well, on page 3 and number 3 and the definition of well monitoring up at the top of the page.
There.
My question is, why is this only looking at water quality instead of other things that could be monitored in a well, like pressure, temperature, seismic?
As I sit here, I wouldn't know the answer, and I would take it under advisement to broaden that definition if possible.
Yeah, and what I would say on mine, and it could stand some further clarification, but when I read that, that's the monitoring aspect of the Class 6 program for water wells. So it's related to water well sampling in the AOR versus the well, but it does say well, and so I tend to think just the addition of the word water well would clarify it, but we can check on that.
Do you think adding another definition for other types of monitoring wells might be useful?
Yes, I would take that under advisement. I'm just, like we've talked about, there's multiple areas where there are definitions, so I would just want to make sure it's not already covered somewhere.
Okay, yes, thank you. Well, Madam Hearing Officer, I'm kind of at a good stopping point if we'd want to break for lunch, and I could continue after, if that sounds good.
Certainly, we can do that. Let's come back at 12:45.
Thank you.